May it please your ladyship and my lords. In this case, as the court will know, I appear on behalf of the appellant, the defendant, and my learned friends, Mr. Stephen Snowden, Queen's Counsel, Mr. John Paul Swoboda, appear for the respondent, who I understand I think is present in court. It's an appeal from Mr. Metzer, Queen's Counsel, sitting as a deputy judge, and we put forward 4 grounds. Lord Justice Coulson refused permission on 1 ground, but gave us permission to pursue an additional ground, which we call ground 5. And I understand from communications with the court that the court would see that it'd be convenient to deal with ground 5 at the outset, but we're in the court's hands. It's not dispositive of the other matters. There are still 3 grounds to be addressed in relation, even if we're successful on ground 5, in relation to the period up to May 2020.
Yes, I mean, the court at the moment has a limited amount of information. The respondent, having accepted that the fresh evidence, as it is so described, could be admitted certainly on a de bene esse basis, it is evidence which certainly has the potential to affect the level of the award, and the court was very concerned to obtain the most up-to-date evidence that they have, that is available. Let me make it clear, we don't want to intrude on any matters of professional privilege or anything of that sort. But it is a significant development, and we wanted to be in the best position to deal with it.
Yes.
Yes.
I think my friend would like to address.
Yes,
Very grateful. My lady and my lords, the position is, as your ladyship identified in the supplementary bundle behind tab 11 and page 14, page 1456 is identified, forgive me, it's page 115 of the second supplementary bundle.
It's the letter of the 1st of October.
It's the letter of the 1st of October from
yes.
those who instruct me. My lady, yes, the position rose in this way. It is, I think, helpful that you know that Sarah Witham, the claimant and respondent to this appeal, told my solicitors what had occurred, and we wrestled for some time with the professional and the ethical duties of what had or had not to be disclosed, and eventually decided that it did and should be. Hence the writing of the letter, and forgive me, it's the clarification, I think, of the 1st of October 2020. And my lady will have read that letter. I don't know whether my lordships have also applied the same scrutiny to it, and forgive me for even questioning that at the outset of an appeal. But my lords will have seen, essentially, the claimant's life and care for her children became very difficult after her husband died.
We have read that, and we've read it with care, and there's no need, Mr. Snowden, and I would like Mrs. Witham to know we have read it very carefully, and there's no need to identify it in open court.
I'm grateful. We'll say no more about that then. The current position is this, that the children have gone. They haven't been returned to Mrs. Witham. She has asked where they are, and she's not been told by Oxfordshire County Council. 2 things are still important. She hopes to get them back. She's not abandoned hope. She hopes, and still hopes, that adoption will at some stage still be possible in the future. The current position is that since May 2020, she has not been their foster carer, and they've been placed elsewhere.
I saw, we all did, that she had raised an official complaint and that there was an investigation being carried out. Again, I'm not seeking to intrude on matters that are covered by privilege or whatever, but has that investigation been concluded?
My lady, no, it's ongoing.
Still?
It's still ongoing. It takes the form of, as far as Mrs. Witham understood, the process that she was able to adopt is a complaints process, and it goes through stages 1 and stage 2. It may end up with an ombudsman. The ombudsman may be able to recommend steps be taken. It may or may not lead to the return of fostering arrangement. It may or may not open the door to potential adoption in the future. That's where that process has got to. We know no more than that.
But Mr. Stone, let's just look where this goes. Because let's assume, for the purposes of argument, that the information comes in at the moment, both you and Mr. Kent are saying that you would like this court to deal with all matters and you wouldn't want us to remit. But how, in circumstances where you've told us that she hopes to get them back and hopes to adopt, how could we possibly deal with it now?
Well, my lord, we say that the clear and the simple way through is to endorse what the judge did. The judge was right, and it is not going to upset them.
That's why I said, assume for the purposes of argument that the loss of the children is capable of affecting the proper calculation of the dependency. I know you don't accept that, and we haven't decided, and we're looking forward to hearing about that. But if we were to come to the conclusion that the loss of the children is capable of affecting the dependency in a way that this court should take note of and try to deal with, how could we bring this case to a conclusion?
My lord, I see the point at one extreme or the other. If my learned friend, if I'm right, it matters not one jot of the judgment stands. If my learned friend is right, and the court takes the view that it is a determining factor, and if my learned friend persuades.
But we couldn't determine that they're not coming back.
My lord, no.
So the answer to that means that we could not determine. We can determine this appeal, but we can't determine the case.
Well, we can begin to determine this appeal. We could determine ground 5 as to the admissibility of the evidence.
Lady, yes.
Where we go after that?
Well, my lady and my lords could still determine the other points of principle, because the full-on challenge we face from the defendant appellant in this case is that the judge erred absolutely in principle, and there should have been no award, irrespective of whether the children were with her or not. So, my lady and my lords can determine those points too. The rest of it stands. I do, however, see my lord's point precisely that the quantification, if one comes to quantification at the end of that, is difficult. May I think about it and return to my lord?
Well, yes, but not forever.
No.
This may be totally off the wall, but is there a power that the court would have in this kind of case to order an income payment conditional on the children being looked after?
My lord, had it been dealt with at first instance?
No, I understand that, but I'm asking now, in this situation, is there still a power to do that? Because in a sense, that would deal with the uncertainties, wouldn't it, if we could do that?
My lord's court were able to order, in effect, periodical payments. Again, maybe contemplate that. I'm afraid I don't know the answer to that on my feet.
No, but Mr. Snowden, I think what this is really highlighting is the practical difficulty that all face, those representing the parties, and indeed the court. And let's deal with practical issues. How do we move forward today? That is, speaking for myself, why I was concerned that we should deal with ground 5 first, because it has the potential to significantly affect the case. So can I, in the first instance then, let me just double check. You okay with just dealing ground 5 alone? Yes. Let's deal with ground 5 alone, and let's see where we go on that, and then work it through. Mrs. Witham, I'm sorry if at times this feels very technical and very legal. We never forget that there are human beings involved, but it is a court which is dealing with law, all right?
Lady, first of all, we are grateful to my learned friends and their instructing solicitors for taking the very proper professional course and notifying us of this change of circumstances. Lord Justice Coulson, in fact, it's Call Bundle page 123, granted us permission to adduce fresh evidence and permission to add ground 5. And we've made some technical points which may be regarded as nitpicking about whether this was a without notice hearing or whatever. We don't want to dwell on that because we accept that an interlocutory order is always capable of being reversed by the same court at a later date if circumstances require it. But, my lady, what we have here is undoubtedly a change of circumstances, and I'll come to the principles on which the court should act in a moment. We came to this court on the basis that we had been told that the children had departed in May last year, and although there were hopes expressed, we've had no further information beyond what my learned friend has only just today informed the court about, and therefore I can see the issue or the problem, which is this an issue even if we are successful on ground 5, which finally disposes of the matter. That may depend, well, will depend on our other grounds, of course, as I think my learned friend recognises. But the position, I imagine, would have been that if this situation had arisen, say, a month before trial, then the trial judge would have had to make his best estimate of prospects. Rather like those in the old days when it was allowed, prospects of remarriage. It's rather like that invidious inquiry that a court might have to make. So we can see that, but we don't have, this court, and we don't have served on us any further evidence. We know nothing more than the date of the 19th of May, which is mentioned in my learned friend's skeleton argument as when the children ceased to be in the Mrs. Witham's care. Lady, Lords, my learned friend's objection to this process really comes under 4 heads, I think. Procedural, well, I'm going to move rapidly on from that. The principle of finality, it's put, and deriving from dicta in various cases, nothing that happens after the death in a fatal accidents case should increase or decrease the dependency.
Well, it is that sentence of Lady Justice Smith, paragraph 50 in Welsh Ambulance Service in Williams.
Yes, exactly. And I know your Ladyship's had submissions about that in another case more recently.
Indeed, I have, Mr.
But dealing with those very rapidly, clearly the Ladden-Marshall principle, if the gateway is opened for the appellant, is an intrusion into the principle of finality. That is, indeed, the appellate system is an intrusion into that. And so we say there's no answer to say, well, the judge says this is what the position is, and therefore that remains set in stone. And so we do submit, and we cover it. I put in a supplementary skeleton argument just dealing with these points, and I don't want to take time on it now because it's in writing. Paragraph 2, I deal with paragraph 3, I should say, the principle of finality, and the cases that I refer to. Supplementary skeleton is at Core Bundle 118. Include Kerwin and James, which was a case where in the days when remarriage or prospects of remarriage of a widow were taken into account, where the widow possibly unwisely married while an appeal was pending, and we cite the dicta. And turning then to the Lady Justice Smith's point in Welsh Ambulance and Williams.
Well, it's at your page 120, the only post-death events which are relevant are those which affect the continuance of the dependency. That's exactly the phrase, isn't it?
Yes, and it's the continuance of the dependency, and this couldn't be a clearer case, assuming, well, even if the children are returned, of course, there will be a hiatus. Couldn't be a clearer case where there is impact on the continuance of the dependency.
Can I just fly a kite, and then I'll leave it be? Does it make any difference if the change in the circumstances, in this case, the loss of the children, is itself attributable to the tort?
Well, we would submit not.
Well, I'm sure you would. And I only fly it because I don't think I'm conscious of any authority which deals with it specifically, and I would welcome your assistance.
Well, but by necessary implication, I suppose, Kerwin and James, the remarriage of the widow. She couldn't have remarried without her husband having been killed.
That's, well, to my way of thinking, that's quite different.
Well, it's a change. It's a change in event. It's a change in the history of the biography of that individual, which is was taken into account before statute intervened.
In Cohen and James, the loss of the husband
Yes.
was attributable to the tort. The decision to remarry was not.
Well, it's attributable in a but-for sense, I suppose. That's the answer. But, my Lord, the answer, as a matter of principle, to your Lordship's question, is that it would be, it would throw up almost endless inquiries, because while Lady Justice Smith emphasises that it's nothing that happens after the death can either increase or decrease the dependency, you would have in a situation like this an argument, possibly, here we're arguing for a decrease, but my learned friend might be arguing for an increase if circumstances had changed as a result of the tort. And one gets into endless byways of
Well, that may be
inquiry.
a reason for saying it shouldn't affect the outcome.
Well, yes, but the answer to that is that then if it shouldn't affect the outcome, then that would be true of all those cases where fresh evidence. Take, for example, a personal injury case where the multiplier might be agreed, Ogden tables applied, and then the claimant decides for his own purposes he's going to go and travel around the world, and he wouldn't have been. He's not going to be looking for that well-paid employment. There would be scope for inquiry that would be endless. But there it is. But to answer your question, my Lord, I don't think I've identified a case which really addresses that. It would have to be argued, I suppose, that the loss that was sustained by the dependents, or one could see the argument it would be a non-pecuniary loss, obviously a loss of family, for example, but we're told by the authorities that it's a matter of pounds, shillings and pence. It is not, there is no award, there's no equivalent of solatium under the Fatal Accidents Act. So I suppose that is also a way of dealing with this rather unusual situation.
Yeah.
So my learned friend also says, well, it's a point that wasn't taken below. Well, necessarily it wasn't taken below. It would be odd if, to satisfy the first limb of the Ladden-Marshall test, you had to show that you had taken the point when, by definition, you couldn't, with due diligence, have known about it. And in this case, of course, we don't. We're not dealing with evidence about some past event that's only just come to light. We're dealing with evidence of an event after the trial, and therefore, by definition, was not available to be identified. And we don't even know now, and we don't want to inquire, why the fostering arrangement has come to an end. So, for example, we could not, and it would have been professionally improper of me, to make random speculative averments or to cross-examine Mrs. Witham to say, well, it may not last. We had evidence from her that they intended, and we entirely accepted that as a genuine expression of her intention, that the children would remain with them and indeed be adopted at the age of 18.
Well, that was the evidence that the judge found.
Yes, but to say that we should have anticipated this point, and it's a point that's not been taken with respect, doesn't really fit in with the jurisdiction this court is exercising.
Because I think the argument is you should have taken account of the contingency rather than you should have taken account of course.
Well, my lord, the answer to that is that it is always taken into account in the multiplier, which contains an element for uncertainty, and there would have been no basis on which we could have invited the judge to shave away the multiplier, which was put forward on the basis that the children will remain dependents until March 2029. And even if we had tried that, it would have made no significant difference. So we would still be...
Sorry, wasn't the multiplier that was adopted for the dependency in relation to the children a multiplier by reference to a term certain? It wasn't.
Oh.
It wasn't like a mortality multiplier which takes into account the.
Well, there's no, because mortality would be largely irrelevant. But
so my lord's point, sorry to keep interrupting you, but so my Lord's point stands, which is there's certainly no sign either in the judgment or in your skeletons that you questioned the certainty of the children remaining with the widow.
Well, the judge deals with he makes a finding. He makes a finding because there was evidence before him which justified it. And I can take the court briefly to those references in a moment. We certainly made submissions about the nature of fostering, which is that the County Council retained parental responsibility and could take the children away at any time, and indeed the foster carer could give 28 days' notice. That was in the documentation, and clearly that's right. That's just a matter of the arrangements made with the County Council. But we had no reason, and all the evidence pointed. We had a care expert who looked at it to this being a settled and happy arrangement that would continue despite the some special needs that the children had. And so there really was nothing for us to bite on in that respect. The multiplier was put forward. We didn't expressly agree it, and the judge dealt with it. If I can take the court briefly to what he said, judgment is in the core bundle, starting at page 37, and at paragraph 5, right at the end, the judge said, although the fostering began as a temporary placement, these were finally made long-term placements in January 2018. So we had that distinction was made. Of course, we couldn't challenge that. And at paragraph 18, quoting, I think, the claimant's evidence, second sentence, she stated she did not take this on half-heartedly and always intended for it to be long-term. And 19, second sentence, she indicated they did not want them to remain. They did want them to remain in long-term placement. She was now considering them for adoption. And he makes a finding at paragraph 27, which is about 6-7 lines up from the foot of the page. She stated that as far as she could recall, the plan for them was always to be placed with a claimant. This is a County Council witness, Carol Noble, on a long-term basis, and knew that the claimant's plan was to return to the full-time work as a nurse. As she confirmed, there were never any issues with the care that they provided, and then described the effects on the family of Neil's illness and so on. And indeed, Malone and friends in closing submissions seem to see it as an issue because at page, in the supplementary bundle, at page 63, in written closing submissions, paragraph 41b, it is of note that Ms. Hannon, the claimant's care expert, calculates the child care for Theo and Evie until they're 18 years old, but Miss Gowan until they're 16 years old, despite acknowledging that foster children can stay with foster parents until 18, 21, or indeed later. Against this context, it is also of note that all the evidence supports the finding that A and B will and would have stayed with the Withams into adulthood. And so there was never any formal admission to that effect, although, as I've already said, we had absolutely no basis for challenging what was being said. And so to say that that's therefore a point somehow we would have taken, let alone a point which would have to be to the effect that the children are likely to remain only for another 6 months. So it's not simply factor in an element into your multiplier, which might have shaved off a year or so, but make a radically different conclusion. We couldn't have done that. And we say that the authorities, even if a party to litigation has agreed an item, it's not likely to have contractual effect if it's been agreed on a basis which was a perfectly reasonable basis, but the circumstances change. Then we say that party should, if the Ladden Marshall requirements are met, should have an opportunity to reopen that. But we didn't formally agree it. And of course, the childcare element was very much, it was a hard-fought issue in the case in any event. My Lord, the only other point I'd like to make before giving way to my learned friend is that they rely in their skeleton and paragraph 23 on the case of Jones, in which Lord Justice May was recorded as saying that the new points, so this is assuming I'm wrong about this, and it is a new points should be allowed only in exceptional circumstances. I hope it's found its way to the court, but this court has recently said that that was wrong as being inconsistent with previous Court of Appeal authority. That's the Notting Hill finance case. It should be tab 22 of the authorities bundle, but it may be that it didn't find its way into the...
Yes.
Well, the court can see, it's really sufficient to notice the head note there that it's a case where there was previous Court of Appeal authority on the point, and the head note simply says this. There was no general rule that a case needed to be exceptional before a new point would be allowed to be taken on appeal, that although an appellate court would always be cautious before allowing a new point to be taken, the decision whether it was just to permit the new point would depend on analysis of all the relevant factors, in particular the nature of the proceedings which had taken place in the lower court, the nature of the new point, and any prejudice that would be caused to the opposing party if it were allowed to be taken. And, my lady and my lords, we obviously there's prejudice in the sense that if this is allowed, that may eat substantially into the claimant's award, but we would submit that's not what the Court of Appeal had in mind in talking about prejudice. It's prejudice in dealing with a point that is coming up late in the day and only by way of appeal, when normally this court will not receive evidence or will not have cross-examination and so on, or order disclosure. In this case, I think I've now accepted that from what my learned friend has said this morning, that we couldn't say to this court, if we otherwise fail on the other grounds, that the 19th of May 2020 has to be a cut-off. Though how the matter would be resolved later would obviously depend on what later happens. Very difficult to predict what that might be, but it's likely. We are now over a year on from that event, bear in mind, with relatively young children in care. We say that
they were 9 and 13 at the date of trial, weren't they?
Yes, and so we say it's quite likely, and I say this conscious that could be misunderstood or offensive to those listening, but it's quite likely that there will be considerable difficulties in the way of.
But we couldn't resolve that.
No, you couldn't. All I'm saying is that it's likely to be significant. In other words, this is unlikely to be a case where we have succeeded. We succeed in introducing fresh evidence, the court permits it, and the court below then says, well, it didn't actually make much difference in the end.
But if this was coming before the court of first instance for the first time, now, in this state of uncertainty, the court would have two mechanisms available to it. One, it could just adjourn the assessment of quantum until there's greater certainty, or it could make periodical payment order.
Yes, well, certainly adjourn. Yes, it would depend on how far the claimant wanted to pursue the point, or was content to say that it's a loss of a chance, as it were. Periodical payments, they're rather more difficult because that requires there to be a state of affairs in place, which requires a periodical payment either for life or for a defined period, subject only to possible changes due to changes in medical conditions and so on. I'm sure my Lord Sir Patrick Elias' suggestion could be done by agreement, like the old structured settlements, where an offer is made on that basis. But I don't, on my feet, I don't think there's a route for the court to make an order of that sort, as it were, a contingent order. I suppose there is the possibility of a declaration, but that's not usually done in personal injury or fatal accidents cases. So, well, what I say is that this is a very clear case where we satisfy the Ladden-Marshall test. We could not have obtained this evidence before by trial. The evidence is such that it would probably have an important influence on the result of this case, well, though it need not be decisive, and that must be a given. The evidence is such as presumably to be believed. Well, there's no issue about that. The evidence comes from the claimant herself. And so we're not advancing a case based upon another witness, for example, which may be controversial. And in those circumstances, we submit that Lord Justice Coulson was right to admit the evidence and allow the ground to be added, and that the consequence is that whatever happens to the other grounds, this judgment should be set aside because it is based upon an assumption that the children would have remained with the claimant until March 2029 in her care. Those are my submissions on.
Thank you.
Mr. Kent, may I just ask? I may be totally wrong. I have a vague recollection that the courts are often rather reluctant to make periodic payments. Is that correct? Is there any presumption one way or the other?
There's no presumption. It's not usually done in a fatal accident case. I think it can be. And it's usually where, in a personal injury case, there's an uncertainty about life expectancy.
Well, they've become pretty popular, haven't they?
They have, yes.
In PI Clinic cases.
They have.
Certainly in respect of care and case management.
Yes.
Because of the uncertainties, particularly in cerebral palsy cases.
Yes. And it gives you your indexation
Yeah.
to deal with inflation in that class, and also your money coming in for the period you need it,
Yes.
however long you survive.
Yes.
But it's slightly. You could have, I suppose, a dependency claim where the life expectancy of the dependent was uncertain. I suppose that's a possibility, unusual. But they are quite frequently done, usually by consent.
Yes, Mr. Snowden.
My lady and my lords, if you will grant me indulgence, I'm going to be a little longer than my learned friend Mr. Kent, because what I hope to do is to illustrate through some of the findings of fact how significant the omission to pursue the issue of the chance of the children being taken away was, that it lay at the heart of assumptions the judge made, that therefore by seeking to adduce new evidence, my learned friend is in truth seeking to advance a new argument, to take a new point. And that does open up for us. And I will then take my lady and my lords to the Notting Hill Finance case and also to Jones, where I hope to show to my lady and my lords that Ladden-Marshall opens a gateway, but whether the Court of Appeal, exercising their discretion, allows a point through that gateway is curtailed or constrained or written around by the provisions of the Jones case and the Notting Hill. And my lords, my lady, there are observations on what sort of cases it's appropriate to allow a party to take a new point in this way, because the new point is, of course, parasitic on the new evidence, as we say. So forgive me, I will be a little longer than my learned friend, but I'll endeavour to be as brief as I may. Your Ladyship, my lords, know that I appear with my learned junior for Sarah Witham, the respondent. And our position, of course, is that the learned judge was right in his approach throughout to this case, and I'll come to that in a moment and the significance of the findings he made, and that each aspect of his judgment was right for the reasons he gave and should be left extant by the conclusion of this appeal. My lady and my lords will have read our skeleton argument, and I'm certainly not going to repeat it verbatim, nor indeed even run through it in the order in which we've written it. But maybe for one moment, may I invite you to stand back and consider what the trial judge did in this case, which we respectfully submit is exactly what one does expect a trial judge to do in a fatal accident claim. He takes careful note of the evidence he hears. He takes careful note of the arguments, most significantly advanced by each party. He makes a series of factual findings, and as is required in a fatal accident claim, all of which are of course different, he approaches the matter from first principles. He identifies whether the claimant was in a relationship with the deceased, which allows her to claim as a dependent, whether there was an expectation of pecuniary benefit, whether it was that expectation of pecuniary benefit arose from that relationship, in this case the relationship of husband and wife and not otherwise. And all along the way of that analysis, the learned judge did what one expects a trial judge to do and made findings of fact and evaluative judgments of the evidence. And he does so by way of findings of fact and evaluative judgments precisely because the authorities, if necessary I'll take my lady and my lords to them, but it's not a controversial proposition, remind us again and again that what a trial judge is doing in a case like this is essentially a jury question. Once one comes through the threshold of entitlement, as Court of Appeal authority, I'll take you if necessary in due course on other points to the case of O'Loughlin. But to say there's no prescriptive means by which a judge should be fettered in deciding the appropriate award, the appropriate recompense for that dependency. So there's a wide gate, and then the judge is essentially answering a jury question, and we say this judge did that entirely correctly. Of course, that makes it difficult to appeal for my learned friend in the other aspects. The evaluative judgments, the findings of fact, could only possibly be set aside if they were so perverse or so extreme that no other reasonable judge could have reached them. Our submission is that it is significant, particularly significant, therefore, that my lady and my lords will have seen from the permission granted by Lord Justice Coulson at tab 13 of the core bundle. The caveat which Lord Justice Coulson applied to the permission he granted under paragraphs 2 and paragraph 3, and for my Lord and Lady's note, that's page 123 of the core bundle. Having identified that permission would be granted on 1, 2 and 3, refused on 4, then extended for 5, he repeated that the argument must be constrained within the 4 corners of the findings of fact made by the judge, and said again, can only be argued by reference to the judge's findings as set out in his careful judgment. We therefore submit that it is important in what is essentially a fact-specific case like this to be clear at the outset, and when we come to consider, when your lordships and your ladyship come to consider whether additional evidence and an additional argument can be advanced by my learned friend, what the judge did find and how that argument by my learned friend fits in with the judge's factual findings. Because that understanding of the factual findings, we respectfully submit, underpins your lordship's approach to this appeal. Some aspects, my lady and my lords, are uncontroversial. You will have in your minds a narrative that Neil and Sarah Witham had been together since 1993, married since 2003, had no biological children of their own, began fostering in 2015. Children who we refer to only as A and B, who were themselves a natural brother and sister, who were then aged approximately 9 and 6. That became long-term, and long-term we've understood, and we believe the judge understood, as a term of art, meaning that in the ordinary course of things, the local authority anticipated that those children would remain with those foster carers into adulthood. It's not a short-term, it's not a time-limited placement, it's an open-ended one. That became long-term from January 2018. We'll see in a moment from the judge's finding of fact that he accepted that the relationship, the family relationship, was such that there was a long-term goal of adoption, both in the minds of Sarah, the claimant, and Neil, the deceased, her husband. My lords, it won't escape you that both children had disorders on the autistic spectrum. both were subject to a foster plus arrangement by which the local authority put particular requirements on the foster parents as to their availability. They needed to be accessible in emergencies if the children needed to be brought home from school, if there were issues at school and so forth. So, in essence, and summarising greatly, one or other of the two foster parents, Sarah or her husband Neil, needed to be available at all times to be able to respond to emergencies, if one can call it that, with the children. We'll look at the findings of fact again in a moment, if you'll permit me to do so, but if I may call them Neil and Sarah, the claimant and the deceased, once they appreciated these children's needs, appreciated and agreed between them that in their ordinary run of family life, he would be the one at home. Now, the expression housewife is one which is not in current acceptable parlance. The expression house husband I use only juxtaposed to identify that, in a sense, that is what this couple had agreed Neil the deceased would be. He would undertake by far the majority of the domestic tasks, and again we'll see that in a moment from the findings of fact the judge made.
We have read the judgment carefully.
I'm grateful. Well, perhaps I'll leave it there. Perhaps the significance of the particular findings of fact, then, if I can take my cue from your ladyship and move to those. My then friend Mr. Kent took you to some, but the significant ones, if my lady has behind tab 5, Lords and Lady have behind tab 5 the judgment of the learned trial judge, page 44 of the bundle, paragraph 38 of his judgment, he identifies a number of findings of fact. I won't repeat those because my lady has indicated that you've read those.
Well, if you just want to identify, you can take us to the specific paragraphs, and if you want us to reread any paragraphs, just tell us.
I'm very grateful, my lady. In those circumstances, it's paragraph 38 of the findings of fact.
Yep.
Paragraph 39. In the middle of paragraph 39, there's the sentence starting just to the right of the centre of the page. Having heard the evidence from the claimant to impress me, I accept her evidence that they had decided. There's a significant finding of fact there.
And it is, I accept her evidence that as a couple they had decided.
Yes. Yes, the significance is of the decision as a couple. And the final sentence of that paragraph, the claimant and Neil had also decided as part of their family life together that would be how the arrangement would work. That is, he being at home and she being the one to resume what was, and again, without being deprecatory about Neil's career or working life as a builder, she was a trained diabetic nurse with a master's degree qualification, and was intending to return to that, which is not only lucrative, perhaps I strained making
Well, she went into bank work, didn't she?
She went into bank nursing,
which
with an
tends
intention.
to be better paid than other work.
Yeah, but lady, yes. But lady, it's the full impact of that final sentence. As part of their family life together, that would be how the arrangement would work, not only in respect to their parenting, but their long-term aim, to keep A and B together, with the intention one day, as the claimant indicated, they would ultimately adopt. My lady, there's a finding of fact which is not relevant so much to ground 5, but to others in due course. The final sentence of paragraph 40, on page 45 of this bundle. The judge finds on balance of probabilities that she, that is Sarah, the claimant respondent to this appeal, would have been able to find similar employment on a full-time basis in the short-term future, which was considered for a foreseeable lengthy period, but for a tragic turn of events. The next finding of fact, my lady, is over on page 48 of this bundle in paragraph 52 of the judgment. And follows immediately after the learned judge's reference to O'Loughlin and Cape, some 7 or 8 lines from the bottom. And it's essentially a cumulative finding of fact over the next couple of sentences. And the reality of the findings of fact set above, the claimant lost her full-time career as a result of Neil's death. She was dependent upon him, as the principal carer for A and B, to allow her to pursue a career for the benefit of the whole family, in the knowledge that their children, albeit foster children, would be properly cared for. In other words, it was effectively the family's loss of Neil acting as principal carer, and the family's finances decreasing by the measure of the claimant's lost earnings. That does not detract from the finding, it is the claimant's loss. So there are findings of fact we respectfully submit there. Perhaps the most... there's a further clear assertion. My lady picked up on the expression of as a family, decision as a family or as a couple, and that's reiterated at paragraph 56 of the judgment, at page 49 of this bundle, where the learned trial judge said, this having found it's the claimant's dependency, it's also necessary to find whether that dependency resulted from the relationship of Neil and the claimant as husband and wife, or was it simply and purely incidental to that relationship for the reasons set out above, distinguishing the present case on its facts from Burgess and Cox. Given the nature of the relationship as long-term cohabitees as a married couple, they would not have decided together to foster A and B and decide that Neil would determine, forgive me, that Neil would be the principal carer other than as part of their relationship. And I find their decision to foster was a joint family decision, not one of business partners, with financial motivation at the forefront. So, lady, what I'm hoping to illustrate is we see again and again the judge doing, as I indicated at the outset, exactly what is expected and making the significant findings of fact, which one...
For the moment, these seem to go much more to ground 1 than ground 5. I hope you'll explain how they fit into ground 5.
My lord, what I'm seeking to do is to paint a picture of the extent of the findings the judge made on issues which, the issues hitherto have all been controversial. We're all controversial at trial between...
But I think with respect we have that.
May I take my lord then to paragraph 62 of the judgment and page 51? Yeah, I'll accept the invitation to move on, but to page 51 and paragraph 62. And it's, again, my lady and my lords, I know, have read this, but this is, in our submission, a finding of fact. In the some dozen lines down, there's a sentence on the left of the page, some words on the left of the page, they are 18, which carries on in this way, from which the undisputed evidence was that he would have stayed with the claimant and Neil into adulthood. I find that, particularly given the autistic and ASD condition described in relation to A and B, the claimant would be, it's not clear whether he means the claimant or Neil, would be likely to remain with them without returning to work until they were both 18 years old. And then that carries on, that particular finding, which, my lord, I do take the hint and will develop into the argument on the admissibility of evidence and whether this is a new point. That carries over, we submit, to page 54 of the bundle, paragraph 71 of the judgment, where again, picking up on what my Lord Justice Stuart-Smith identified as my learned friend, perhaps mischaracterising some sort of discount for contingencies being made. My Lord sees there that the learned trial judge, applying the claimant's schedule of loss, my findings in relation to the dependency of the claimant on the deceased's childcare and domestic services from January 2019, and applying the Ogden 28, so the simple numerical year's purchase multiplier, as my Lord and my Lady will both appreciate. In respect of March, by which I think he means March 2029, by which time the children were 23 and 19 years old, he then goes on to perform the calculation, but that is, we respectfully submit, in effect, a finding of fact which springs from the one I took my Lord Sir Patrick Elias to a moment ago at paragraph 62, a finding on undisputed evidence. There was no challenge, there was no argument as to a discount for contingencies. There's no argument as to a discount for the chance that the children may be taken away. There was no argument of discount for a chance that Sarah and Neil, indeed nor could there have been given the evidence that Mrs. Witham gave, may have wished themselves to have brought this fostering arrangement to an end. So it's simply a point that is not taken at all. And where we go there is to move from those findings of fact, if I may, and then straight into dealing with ground 5. In effect, my learned friend characterises the evidence as a new and startling development which so upsets things that it must be seen as, not his words of course, but something of an improper windfall for the claimant which should be taken back from her. That's the gist, or that's the effect of the argument that the defendant advances in this case. We hope to demonstrate that that is not so at all, but we pause before coming to ground 5, or delving deeper into ground 5, to observe only this, as my Lord Justice Stuart-Smith and my Lady Justice Davies will know, that what may at first appear an illogical outcome is not uncommon under the Fatal Accidents Act. It's a unique statute. Its focus is on the dependency itself. That is what the deceased would have done for the dependents or dependent. And the assessment is made at the time of death, and we'll come back to that in a moment, but my Lady Justice Davies observed that earlier from Lady Justice Smith's comments in Smith and Welsh Ambulance.
Yes, I know there are observations in cases that what happens post-death is irrelevant, and the classic could be that where you've got a family business, members of the family have managed to carry it on and it's done better, and the authorities say you don't take account of it, and there are observations in different cases from not least Lady Justice Smith that it may well be people are overcompensated. This, speaking for myself, is of a wholly different nature. This is a significant change in circumstances, and one that goes to the core of the calculation of dependency as set out in 71, because it was on the basis the children were staying with Mrs. Witham.
My lady, that's entirely correct. But the question, and I'll come back to it in a moment if I may, is whether it is right at this stage to upset a calculation when there is almost inevitably some illogical incongruity, some sense that the outcomes under the Fatal Accidents Act are not always logical. They don't always chime. They sometimes jar, particularly from a defendant's point of view, in terms of what's being awarded and what is not required to be given credit for. But I'll come back if I may, because what I will do in a moment, if my lady and my lords will allow me to develop in the order in which I'd like to, come back to the point which we anticipated my Lord Justice Stuart-Smith was going to make as to the nature of the events which go to displace the presumption, the assumption, the approach of assessing dependency from the date of death, and ignoring that which may or may not happen thereafter. Because as my lords and my lady know, the disregard of events since death, and indeed within the Act itself, the disregard by Section 4 of benefits arising as a result of death does sometimes lead to results which we accept to some ears may jar. Perhaps the classic illustration of which is Williams and Welsh Ambulance itself, where on any basis the court was required not to consider the success which the family continued to make of the deceased's business after his death. So recovery was based, broadly speaking, on the loss of the wealth creator, Mr. Williams, ignoring the fact that the business had continued being at least substantially as successful in any event.
That's what I was saying.
Yeah. But what we draw from that, and if I may, just to step back for a second, is to suggest that an outcome which may at first blush jar does deserve scrutiny, but is not necessarily wrong. And I hope to persuade my lady why the outcome would not be wrong in this case. My late friend contends that Sarah, with the claimant, should lose a substantial sum of her damages because chronologically after the trial, the factual matrix changed and the two foster children were taken away. Or more accurately, they were not returned to the claimant after a period of respite care. The defendant does invite the court to treat that, admit that as new evidence, and on the back of that, advance a new argument. Because evidence doesn't speak for itself, and what my learned friend says is, in a sense, we now have the factual matrix that the children have gone on one extreme of this case, subject, of course, to my lady's observation as to the lack of certainty of the current position. We say, we respectfully submit that on ground 5, my learned friend should fail for the following reasons. First of all, allowing this to be advanced as new evidence or a new argument is contrary, we say, to the established authority on finality. And in that regard, I'll take you very briefly to Adam Marshall. Perhaps its provisions are so familiar that my lord and my ladies don't need to be taken to it. Then we will take you, if I may, to Jones and to Notting Hill as to the extent to which the court should, at this stage after trial, now allow a new argument to be developed. But we say, almost as importantly, on careful analysis and having looked at the findings of fact and the permission given by Lord Justice Coulson, allowing the defendant to pursue ground 5 today expressly, Lord Justice Coulson's permission expressly tied the parties to the findings of fact made by the judge, and this was a finding of fact made. The undisputed evidence, we say, the reference to paragraph 62 of the judgment, page 51 of the bundle.
But that would make it impossible for any Latin Marshall case to succeed. Because, of course, one is questioning the finding of fact, not because the judge made an error, but because things have changed. It's inconceivable that Lord Justice Coulson meant that this is admissible evidence, but you can't change the conclusion of the judge on these matters.
Well, my Lord, we say that what Lord Justice Coulson recognised, and what I've endeavoured to impress upon my Lady and my Lords, is the thoroughness with which the judge made findings of fact underpinning the judgment. And my Lord, what I'll endeavour to show in a moment is quite how significant a change it needs to be, and how the circumstances of the case need to be to trigger the discretion from this court to allow a party to raise that new evidence on the back of which to adduce a new argument. Because there's a distinction, I submit, to be drawn between allowing the new evidence to be adduced, which would have a bearing on arguments that have already been run, but that's not this case. This is new evidence on an argument which had been disavowed or conceded. So this is not simply allowing new evidence, this is allowing new evidence which gives rise to a new and different argument, which I'll develop in a moment, would have led to the trial being conducted very differently had that point of principle, that is, that there's even a chance that the children...
That may be right, but it's a different argument from the one saying that the findings have been made and you can't allow fresh evidence to interfere with those findings.
My Lord, yes, I did say that. Excuse me, but our further reason for suggesting that ground 5 should fail is we'll look at, I'll take my Lord and my Lady, my Lords and my Lady in a moment to Lady Justice Smith's judgment and develop the idea that, excuse me if I may, what sort of events post-dating death should make a difference and what sort of events shouldn't, picking up, if I may, on my Lord Justice Stuart-Smith's point of the relationship.
Can I just see where we're going on this? Because obviously, given the chronology of how this has developed, ground 5 potentially has a lot of money attached to it.
Yes, it does.
But the argument would apply equally if it were discovered that as a matter of subsequent fact, that the period of looking after the children was too long by a month, or 6 months, or 5 years. And equally, would it not apply equally to an argument that it could now be seen that in fact the dependency would have been greater, because the time required would have been greater? Those would both be subsequent facts that on the face of it undermine the veracity of the findings.
Well, if my learned friend's formulation is correct, then yes, they would. And my Lord, what that illustrates is the panoply of matters which, if my learned friend is right, could and should be taken into account, but we say shouldn't.
Well, it may be my observational question, if it can be called that, is for Mr. Kent rather than for you. But at the moment, there's nothing special about the point at which the children have been lost, is there? Apart from the fact that it has a lot of money attached to it.
My Lord, no. But what it is it's not a pointer. It's not an evidential development of the kind which was identified by Lady Justice Smith in Williams.
But that's the point.
Matters related to matters which would have occurred in any event, independent of the tort. The dependent would have died is the classic example. That's not something which simply adjusts the dependency, the ongoing value of the dependency, which is what the point my learned friend is raising would do in respect of Mrs. Witham. It brings it entirely to an end because the dependent's gone, the dependent's died. That's an extraneous event which would in any event have occurred irrespective of the tort. The other category of events which Lady Justice Smith identified as being those which should be taken into account as between the death under trial are, well, she didn't say taxes, she said inflation, death and taxes being the only two things which are certain. Perhaps in her mind, death and inflation. But those were two events which she pointed to as being so significant. But again, what one sees with those, if one thinks about it, is that neither of those is in any way related to the tort, to the underlying act of negligence. Those are matters entirely extraneous to the factual matrix of the case, which would have occurred in any event. So one can see that there's a categorization, we say, of events which should be taken into account. And they're limited in that way to extraneous events unrelated to the tort, which would have occurred in any event. One of which, of course, the death of the dependent, brings the dependency to an absolute halt at that point at all. It's not simply an adjustment of the dependency figure.
So on that submission, if in a mesothelioma case, by some ghastly mischance, the death of the survivor was attributable to the same exposure, you would be saying that makes a difference. Accepting that a death through natural causes of the survivor brings a dependency to an end and is capable of being brought into account retrospectively.
Yes.
On your submission, it's a bit outlandish, but it's not completely outlandish. If the death were attributable to the tort, same tort, it would apply in a car crash.
Well, there is such a case. In fact. There is such a case.
You don't surprise me, Mr. Kent. I just don't know.
My Lord, Sir Patrick Elias was in it, and I can't remember the name of it, but it's where both husband and wife were exposed. The wife to the husband's work clothes, and she died, thereby shortening. She had a Fatal Accidents Act claim, and she had her own claim, which was foreshortened because her dependency was thereby shortened. It may be we ought to look at that. But,
I can't recall it, and I hope I didn't give judgment.
Your Lordship did, I think. But I'll try and recall.
I hope I wasn't counsel for the defendant.
Lord, may I come back to that in a moment? May I start with, I'll do this briefly as I may, with the principle of finality. My Lady, my Lords, our skeleton deals with this in paragraphs 16 through to 20. I won't take you back to that, save that I'll emphasise, if I may, simply a reference to paragraph 18 to the extract from Mulholland, rather than take you to the case of Mulholland. And that's tab 11 of the core bundle, page 5 of our skeleton, internal page 97 of the core bundle. My Lord, simply repeating paragraph 16, the general principle is there must be litigation finality. That's not a proposition which is contested. In paragraph 18, Lord Wilberforce's, the extract from the speech of Lord Wilberforce, negatively fresh evidence ought not be admitted when it bears on matters falling within the field or area of uncertainty in which the trial judge's estimate has previously been made. Positively, it may be admitted if some basic assumptions common to both sides have clearly been falsified by some subsequent events, particularly if this happened by the act of the defendant. My Lord, we say in this case, in effect, the trial judge made an estimate of probabilities, and his estimate was pitched at the 100% level, that it is overwhelmingly likely the children would remain.
So with the survivor, normally survivorship is assumed.
Yes.
But you may have a case where the issue is whether the survivor would survive for the relevant period.
Yes.
And your submission, as I understand what you're saying now, would be that if it were in that latter case and the judge had said, I make a finding that this issue having been raised, it's likely to be X or something like that.
Yes.
Then you would say that would take survivorship out of the category of things that could be referred to or retrospectively reassessed.
Yes. I do. And may I explain? First of all, as a matter of principle, that's what we say moral Holland means. But as a matter of practicality, how that applies, may I take my lords to the authorities bundle and to the case of Jones, which is at tab 14 within that bundle. So, and what again, to emphasise, what I'm inviting my lady and my lords to consider is not that this is simply a piece of new evidence, but this is a piece of new evidence with a new argument attached to it. The defendant is seeking to run an argument that it chose not to run or advance below. The Jones case is a decision of the of my Lord and Ladyship's court. The facts are, I dare say, irrelevant for these purposes. It's to do with a banking employee dismissed for gross misconduct. But, lady and my lords, may I take you to paragraph 52 of the judgment? May I just, for one moment, check it is the judgment of Lord Justice Peter Gibson, yes.
I'm so sorry, Mr. Snowden, I was writing. Which page or paragraph?
Paragraph 52. And my lady and my lords, essentially, it's the entirety of paragraph 52 which I would refer.
Should we just read?
Cool, I'd be grateful if you would. I'm grateful. I won't read the paragraph to you in those circumstances, but we simply emphasise that it's not just about the principle of finality in itself, it's about the inappropriateness or the unjustness of a party facing on an appeal a case advanced on a basis which had been opened below, but wasn't advanced below. And that's the situation we respectfully say we find ourselves in. May I take you then to the Notting Hill finance case, which my lady and my lords will find at tab 22 of the authorities bundle.
Before you do that, let me just ask on a practical level. I mean, my reading of what is a very careful judgment, where the claimant was described as an impressive witness by the judge, is that the evidence was all one way. This was a long-term arrangement. It had been recognised by the local authority as a long-term arrangement, and the judge accepted the evidence of the claimant that not only was it to be long-term, but the hope was that it would be adoption.
Yes.
It was one way, that evidence.
It was one way because we say, the point wasn't taken and nothing was adduced against us. Now, as my lady might ask rhetorically,
in order to take a point, you need an evidential basis.
What Mr. Kent might have done, I was going to say, my lady might ask rhetorically, how could this point have been taken? Yeah. Well, it might have started with some statistics. And of course, my response to that, and the judge's response, and indeed my lady's response, were you trying the case, might have been, well, statistics are objective, and I make a subjective judgment of this couple and these children in those circumstances. But some evidence or some material could have been adduced by my learned friend had he sought it from the local authority as to how many foster placements do indeed last that long, what the triggers might be to end a foster placement prematurely.
There was some evidence, wasn't there, from the expert? Their expert didn't accept that the period of dependency would be as long as your expert was suggesting.
Yes, that was not so much based on the duration of the foster care arrangement as on their experts' rather scathing is the wrong word, no, rather harsh view of how much assistance these children needed, despite having disorders on the autistic spectrum.
But I thought it went to period as well. Does it not go to
It
period?
goes to the period in the sense that she had formed the view that after the age of 16 they wouldn't need any further help, so
Right.
the dependency would end then. It wasn't that she had formed the view that there was a chance the fostering relationship would end. Her assessment was based on she didn't think they'd have additional needs, or any needs, beyond the age of 16 or so. It was a particularly, we characterised it below, and I'm happy to say so again, particularly harsh view of the needs of two children who'd been diagnosed in this way. But it wasn't offering evidence on the potential for the fostering arrangement to come to a premature end. That's the better way of expressing it. But that would have been open to the defendant to have pursued at trial had it wanted to. What could have been done would have been deploying, for instance, any guidance as there might be, such as to the circumstances in which fostering, even long-term fostering arrangements might come to an end. There may indeed, my knowledge of family law is scant, and it may be that with your experience of hearing cases on appeal, my lords and my lady have further experience than I do, but one wonders perhaps even about the intervention of the children's natural parents, whether if they'd found themselves in a different place or position, they could have applied to have had the children back to them, and that would have brought the fostering arrangement to an end. So there are any number of potential permutations which could have been explored, not necessarily with Mrs. Witham, because my lady is right, Mrs. Witham's evidence was only one way that this was.
I think Mr. Kent would say, well, so be it. Even if that had been done, this is fresh evidence. This isn't an issue arising out of statistics, as it were. This is something over and above statistics, which is very very fact-dependent on the circumstances of this case. And that couldn't have been foreseen. Statistics could be foreseen.
My lord, I do see that, but what I'm endeavouring to establish, forgive me, I'm doing it inelegantly, is that Mr. Kent's point now is a point which he could have pursued in kind.
Well, that might be
below.
a critical question, might be whether it's truly in kind or not.
Well, my lord, we respectfully submit that it is.
Well, I appreciate that.
Of course, forgive me. But it is precisely what we are saying. Had Mr. Kent raised it below, the parties could have, would have probably conducted the matter differently, and we'll see how that plays out in Notting Hill Finance in a moment. But evidence could have been adduced, questions could have been put. Mr. Kent could have questioned the local authority social worker who was involved in this family as to the sorts of conditions and chances and exigencies that might exist. The children might might leave this foster placement before the age of 18. And it may be that on the back of that, Mr. Kent might have been at something of a disadvantage, given that the local authority clearly considered that these were extraordinarily adept foster parents. And this was a relationship which they would support, as they understood it at the time.
Well, that's why I was saying that the evidence was all one way. And it really goes to the point that my lord's Patrick Elias was making. This is evidence of fact which couldn't have been foreseen.
It is, but my lady, if my point's not a good one, it won't improve with repetition. It's
No.
an argument of that it won't. But it's an argument that a contingency of that nature could have been argued by Mr. Kent, even if it was a broad brush 10%. Let's take 20% off.
The critical question is whether it's an argument of the same kind. That's
Oh,
what we really have to decide.
Yes, it is. It is. And in my submission, it is, because in a sense one sees... no, I'll come back to that in a moment, if I may. May I take my lady and my lords to the Notting Hill Finance case, which, as I say, is tab 22 of the authorities bundle. And the red lining, my lady and my lords will see, runs from paragraph 21 of the judgment on internal page 5 of the printout, I think. It's Notting Hill Finance and Shake, 2019 4 weekly law reports, 146.
Do you want us to read all the redlining?
Would you? I would be
Yes,
very
certainly.
grateful if
Yep.
my lady and my lords would read the page and a quarter that's redlined. Which page is that? 21 to 28.
Thank you.
Lady. The particular passage to take you to within that, or to emphasise, if I may simply, is paragraph 25, and the principles described as being restated by Lord Justice Haddon Cave and Singh and Das, and within that judgment of Lord Justice Haddon Cave, paragraph 17, as is set out here, an appellate court will not generally permit a new point to be raised on an appeal if the point is such that either A, it would necessitate new evidence, or B, had it been run below, it would have resulted in the trial being conducted differently with regards to the evidence at trial. And my lord, what we see the court doing here is in a sense distinguishing between a point which it is comparatively easy to bring in on an appeal, that is an argument of law perhaps, on facts which are uncontroversial, which couldn't be controverted. What becomes more problematic when we do rely on Lord Justice Haddon Cave's judgment in this respect is where the point should have been and could have been raised at trial. If it had been raised, the trial would have been conducted in a different manner, and the judge would have effectively, within his judgment, encapsulated the sort of risk and the sort of argument which Mr. Kent now advances. So summarising our points in this, I won't dwell on them any longer, but the first point is this: the defendant did not raise at trial uncertainty over the duration of the fostering or the risk that it may be cut short. That's abundantly clear from the skeletons in the judgment. The fact that it has been cut short now, as we understand it, is but one aspect of the argument which was open to the defendant but not run by it below, that it might have been cut short. It is part and parcel of the same argument which was disavowed below. What should the defendant, or could the defendant have done? Adduced some evidence on chance, cross-examined the claimant, cross-examined the social worker, made submissions even broad brush as to percentage chances or discounts. What if the defendant had done that? We say we would have marshalled our evidence differently. We may have sought further witnesses as to the likely longevity, so as to have given some clarity to the judge when he is endeavouring to ascertain whether there is any contingency discount at all to be applied, any uncertainty, any, as Mr. Kent expressed earlier, that he thought he'd obtained some uncertainty in the multiplier beyond the bare multiplier from table 28. What might the judge have done?
Well, the trial would have been conducted differently.
It would indeed.
Because, at the very least, Mr. Kent could have cross-examined Ms. Noble or somebody
Yes.
about the fact that nothing is certain in fostering and adoption, and that with the best will in the world one can never foresee, and so on and so forth. He may not have got very far, but that would have been a course that would have been open to him.
It would, and it would have raised the issue, and it wouldn't then be a new point being raised for the first time now.
And if at the end of that process the judge had said, well, I recognise that the dependency may not be so long because things can go wrong, but I'm going to settle on a dependency of whatever it was, 8.41 multiplier or whatever it was, I can't remember. Then you say that would clearly have capped or prevented ground 5.
Yes.
Because it would have been encompassed. What
been.
has happened would have been encompassed in the risk.
Precisely. We would have had an opportunity for addressed argument to it if the judge had said there's a 70% chance the children will stay, and taking entirely arbitrary figures, a 30% chance that they may not stay.
Well, you're back to the normal personal injury problem of compensating for uncertainties.
Compensating for uncertainties, precisely. And that's one course that would have been open to the judge, and my lord and my lady will have seen that we've elaborated on that on Skeleton. There's authority for that in the fatal accidents case. And I won't take you to that now. But the judge might have done that. And if the judge had done that, and there had been a 30% chance that the children would not stay for the full duration up to adulthood, and the events which have now transpired did transpire, could the defendant have appealed? No. So what we've got is a position we respectfully submit now, where a defendant who chose not to run that argument at all at trial, when we accept it might have been at best for defendant, it might at best have led to a percentage reduction. Why is it right the defendant is entitled to take that argument now, when, as things stand, if the children aren't returned, it is an entire knockout blow? And we respectfully submit that there is considerable prejudice. Not just unfairness, that's evident. Not just, we say, injustice, that's evident. But prejudice in the sense of we haven't had a chance, we didn't have a chance at trial to respond properly to that argument, so as to get a bolted down assessment from the judge who'd heard the evidence, had seen the witnesses, on that.
And the judge might have knocked 100,000 off your dependency claim.
He might indeed, because it's a jury question, it's a broad brush question, as the Lord knows we would come back and say on the other points, and indeed my Lord knows from the Lordship's own experience. There's an almost unfettered discretion as to how a judge in first instance would approach this. He could have knocked some off, he could have allocated a percentage, he could have tweaked the multiplier by 1 degree or another. So with the greatest respect to my own friend, that combined with that extrapolated out of the principles elaborated here in the Notting Hill Finance Judgment, paragraphs 25, 26 and 27. But we respectfully submit simply that it doesn't lie in the defendant's mouth to go back now and raise an argument for the first time when it becomes an argument of catastrophic effect on the judgment, when they could and should have done it before, and it could then have been dealt with properly and thoroughly on the evidence as it then stood. What we do say is this: it's not simply a tug at the heartstrings point. It goes to the overall fairness, appropriateness, justice, prejudice of the argument. On any basis, the claimant is now, due to the defendant's negligence, a widower who has lost her foster children and has fallen off the career ladder. Again, there's a finding of fact in the judgment. I don't need to take you back to that, but her nursing registration slipped in July 2019. All of those matters are a consequence of the tort. And in weighing up the scales of whether it's right or fair or where prejudice lies in allowing the defendant to admit admit this new evidence comes back to the sense that I think my Lady Justice Davies articulated, that it almost feels wrong because there's such a significant sum at stake. But does it feel so wrong in that context? We respectfully submit no. Given that there are jarring implications of the Fatal Accidents Act in any event, this is no more jarring than many of those. And it is, we say, where we respectfully submit where the balance of what is right and fair falls. May I then come to the point on Williams? And it's helpful if we may not need to look at Williams in detail, but forgive me, I've lost my page. It's tab 19.
Sorry, tab 19 of...
Sorry, tab 19 of the authorities bundle. Forgive me, the case of Welsh Ambulance Services and Williams. And my lords, this goes to our submission that it is in any event wrong or inappropriate to allow a learned friend to advance ground 5 because we say on a correct construction of the law relating to Fatal Accidents Act, as Lady Justice Smith says at paragraph 50 here in Williams, it should make no difference. And this comes to my Lord Justice Stuart-Smith's point as to the nature of the events. Would my Lady and my Lords simply read paragraph 50 rather than have me read it to you? Not sure whether I'm anticipating a question.
No question.
Oh, great. The specific sorts of exceptions which Lady Justice Smith countenanced are not broad for those matters which one should take into account as events post-death, which should influence or have a bearing on the extent of the financial dependency found by the court. Those which affect the continuance of the dependency, such as the death of a dependent before trial. So, well, again, that I hope simply explains the submission I made earlier about an independent event, something not related to the tort, an extraneous event which would in any event have occurred. And we say her only example she offers is the rise or fall in earnings to reflect the effects of inflation. Again, that's the same sort of nature of thing. It's something which is independent of the tort. It's something which would have occurred in any event. It's an extraneous supervening event, I suppose, in that sense. And those are also events which are permanent, we say. Not so here with, on our case, the removal of the children. A complicating factor, as my Lord Justice Stuart-Smith identified earlier, is that as a matter of factual causation, in this case, the removal or the non-return of the children to the claimant is, on what we know and understand, caused, at least in part, by the death.
Well, can you say that? I'm not sure you can make any argument about the reasons any more than Mr. Kent can. I'm not sure the court can begin to go down that line.
And I'll accept that I can't adduce evidence, but the basis on which the evidence is, such evidence as there is, which is the letter is being admitted de bene esse, is the explanation within the letter that Mrs. Witham was unable to cope in the absence of her husband. And one can juxtapose that with the judge's findings, which, in glowing terms, described how complementary they were in their parenting style, how one was able to deal with one child, not another. They made a good team together. And it's beyond speculation, with the greatest respect we do submit, to suggest that his absence, his death, has made a material impact on her ability to deal with the children. And that, as I say, is the gist of the material that's been admitted to NASA for the purposes of this argument. So I do maintain it to that extent. I can't elaborate on it, I can't give evidence, there's no further evidence before the court. But the description that the court has, and has admitted for the purposes of this argument.
But even if that was so, why would the compensation properly be referable by the cost of looking after children who are not being looked after?
The point is that it is an aspect which the trial judge had already decided, I think is what it comes to. And that it is not an event of the kind which Lady Justice Smith described as being an objective, unrelated to the negligence, unrelated to the tort, sort of event, and it is not the kind of events which she describes are permanent events, as I say.
Is your submission that Lady Justice Smith's phrase "continuance of dependency" is referring to the existence of a dependent who is or would be dependent upon the deceased? So
Yes.
that clearly ends, not
Yes.
events which happen to increase or decrease the quantum of the dependency. Because if you go back to the previous paragraph, she sets her face against events which show that the benefits are either greater or lesser than had been anticipated.
She does.
So she says it's irrelevant that as things turn out, the business does better or does worse.
Yes.
So is your submission that that's the true analogy, that it's irrelevant whether, as a matter of fact, the children are more demanding or less demanding, or even whether they leave sooner than later, because that's quantum
Yes.
rather than the existence,
The existence
of
of dependency.
dependency.
It's
Is that your submission?
It is. Yes.
I'm not giving any
No,
indication.
no. I appreciate it.
And I'm talking as much as I am simply because I find this extremely difficult.
But my lord, yes, our submission is that must be right from the language that Lady Justice Smith used when she talks about continuance of the dependency, such as the death of the dependent before trial. She doesn't talk about the continuance of dependence in the ups and downs of the financial circumstances.
Sorry, I'm just not understanding this. Do you want to make this one clear, please? What are you saying that actually means? The continuance of the dependency?
Continuance of the dependency is the continuing life of the dependent. What I'm saying she can't mean is a variation up or down in the extent of dependency, because, as my Lord Justice Stuart-Smith observed, Lady Justice Smith rather set her face against that in paragraph 49, immediately preceding. So she must, we say, mean something different. It must mean the absolute cessation of that dependency because the dependent dies. My lady, I won't take you to it, but those sorts of caveats are to be found in the extract from McGregor on damages, which, for my lady's note and my lord's note, is at tab 2 of the authorities bundle. Lady, there are red line sections which I won't take you to now, but they, in effect, adopt and recite the exceptions, if I can call them that Lady Justice Smith articulates in paragraph 50 of Williams and Welsh Ambulance. My learned friend, in his supplemental skeleton, seeks to say that there's a broader range of events or uncertainties that could or should be taken into account in post-death in determining the dependency. One of those he refers to as the case of Kerwin and James, which was an old decision where as my learned friend accurately summarised, the widow remarried before an appeal, and that was taken into account. But, my lords and my lady, there are two important caveats to that. First of all, the case of Kerwin and James, which I won't take you to, but for reasons of time, but simply to emphasise, was decided under the old rules of the Supreme Court in 1963, when an appeal was a full rehearing. It was in effect an entire retrial of the matter. So all that was essentially established by that, we say, one can deduce, is that at a trial of first instance, events such as that might, in those circumstances, have been relevant. And they were relevant because a widow's prospects of remarriage were relevant in 1963 to the nature and extent of her dependency. But that itself has now been overtaken by the statutory disregard of a widow's prospects of remarriage in section 3.3 of the Fatal Accidents Act. So Parliament itself has chosen to do away with that potential factual change as being one which should affect the extent or the nature of a dependency. So Kerwin is an old case decided under previous rules and is overtaken by the change in the Fatal Accidents Act. My lady and my lords, we've elaborated more there's more in our skeleton than I have said in relation to ground 5. For instance, as reference there to the case, or is there? No, because my learned friend raised it later. The case of Williamson and Thornycroft, which he hasn't elaborated on in his oral submissions, but is in his written ones, is a case of a death of a dependent. So it is a classic example, but predating. It's not an example after Lady Justice Smith. It's many years before, but it's the sort of category that she had in mind. It doesn't extend the principle beyond the way in which Lady Justice Smith has described it. So I have covered in a different way, and I hope slightly elaborated on paragraphs 10 to 31 of our skeleton. We don't resolve from anything that's there in writing, of course, and commend it to you. One final aspect we do raise is this, which is as an illustration of the uncertainty, if you like, the good reasons articulated in the Notting Hill Finance case for why a party shouldn't be allowed to do what Mr. Kent seeks to do. At paragraph 31 of our skeleton, we say, well, really, what happens next? Do we go back for a retrial? Do we go for a retrial now on the assumption that the children have gone, if that's being raised as a new argument? Do we somehow go back for a retrial on the assumption that the judge must put out of his mind the children have gone, but assess the chance or the possibilities? It's an unsatisfactory and it's uncharted territory. And it itself, we say, shows the difficulty of acceding to my learned friend's request to put this evidence in that it has uncertain consequences. I'm not sure, lady, whether I can assist further.
Thank you very much indeed. Kent.
Ladies and Lords, it may be a jury award, but that doesn't, of course, mean that the court has carte blanche. If this case had come to trial in July of last year, after the children had left Mrs. Witham's care, then clearly the award would have been very different. Lord Justice Coulson himself said in his period 1 of his order granting permission, this event could have a radical effect on the quantum of damages. And clearly Lord Justice Coulson wasn't then contradicting himself by saying that nevertheless this court had to decide the matter. on the basis of findings made. My learned friend's recitation of the findings of fact made by the judge, some of which I took the court to, merely illustrates the point that he, understandably, on the evidence before him, made findings to the effect that this would remain a long-term arrangement. What we now know is that that is completely unreliable. As was said in one of the cases which I refer to in the skeleton argument, the court should never speculate where it knows, and this court has the advantage of knowing. Now, I accept we don't know the final act of the story. We don't know whether this event, no doubt a sad event from the point of view of Mrs. Witham, it has anything to do with the fact that she has struggled on her own, or there are other reasons. The children remain in the care of the local authority, or they did. We don't know where they are now, and I understand have biological parents. There are all sorts of reasons why a fostering arrangement might come to an end, which is no reflection on the foster carer or on the circumstances which lead them to be a sole carer.
And if this trial is listed for November, remitted for retrial in November, and the children come home in October?
Well, that is the sort of evidential problem that courts have to grapple with every day of the week. That there is
it is one of the reasons why the courts look for finality in litigation. Well,
subject to the right of a party to appeal. And my own friend, citing Lady Justice Smith, says this is post-death events are not to be taken into account. And we've cited Williamson. In fact, in the extract from McGregor, tab 4, tab 3, tab 2, there's reference to internal page 1469. It's paragraph 41-032, part of the guidelined part. Changes before the decision of the court of first instance, which refers to a case right at the end of the Swin Fleet, a dramatic illustration, a claim arising out of the death. So it's a fatal accidents case, death of 2 English seamen in 1939 in a collision between 2 ships, heard some 8 years later, after the Second World War had ended and after seamen's wages had increased enormously. And so, and indeed Lady Justice Smith herself talked about inflation affecting the earnings level. So that's an example of events which are taken into account, not simply, so this question, what does the continuance...
But that's events before the trial.
I accept that, but I'm sorry, I'm jumping on to my lone friend relying upon Lady Justice Smith saying the assessment is that the loss is assessed as at the date of the death. There are 2 separate points, which is what my learned friend could not have argued, we would respectfully submit, if the case had been tried last year, that the court should shut its eyes to what had happened and should then just view the matter as at January 2019 when Mr. Witham died, and look at the expectations then. That we respectfully submit it cannot be right, and is not, it clearly isn't right, because that's what Williamson and Thornycroft disavow, and other cases, Kerwin and James. And so we are facing, therefore, a complaint that somehow it's our fault for not raising a point, which, if we had raised it, might have raised some eyebrows, because on what possible basis would we have been putting, either by way of cross-examination, which might have been regarded as offensive, or by submission, that there would have been a significant chance of this not continuing. And if we had raised it and the learned judge had said, well, I'm going to shave a year off the multiplier, I'm not sure whether my learned friend then accepts, I think he probably does, that we could come to this court and say that was a wholly inadequate discount because of what has now happened. And it would be a triumph of form over substance if we were allowed to do that, because as it happened, we had taken that particular issue, or left it undecided, left it to be decided by the court. And indeed, and yet, if something was even agreed, as it might be, because the evidence is all one way, the other party is prevented. The Swin Fleet is an example where the claimant would, of course, be wanting. If the Swin Fleet had been tried in 1939, but then, well, I don't imagine they'd be allowed to appeal 6 years later, but if there'd been a change, dramatic change in wage levels, then no doubt the claimant might be saying the court has proceeded in all innocence on a completely false basis. It works both ways. And although my learned friend talks about prejudice, it's not quite clear what that prejudice is. It's saved that both parties obviously are in the unfortunate position that material has emerged after the trial. And so and that can go one way or the other. The case I was thinking of, just while I remember, I managed to find was a case where both husband and wife were exposed to asbestos. Was Haxton and Philips Electronics, 2004.
Say that again, Mr. Kent.
Haxton, Haxton, and Philips Electronics, 2014, 1 WLR 2721, and my Lord Sir Patrick Elias, presiding, said that where the widow's claim for the dependency was confined to her own now shortened life expectancy, but she had her own personal injury claim, and this court allowed within that claim a lost years award for the lost value of her litigation claim on the basis that it was a foreseeable consequence. So I would have thought rather unusual facts, but that was the case I was thinking of, whether that quite fits this scenario, because that was actually, it wasn't within the four corners of the fatal accidents award, which was accepted, would have to be decided by reference to her reduced multiplier, reduced life expectancy, but was decided on the basis that she could get that home, as it were, within her personal injury award. Very unusual situation.
And there isn't any scope either under the Law Reform Act or as a direct claim or under the Fatal Accidents Act to, I'm going to say compensate, and I don't mean that in an offensive way, but to recognise the fact that she has also lost the children.
Well, sadly, no. That's the point that we make in our main skeleton argument. Those old cases, Davies and Dufferin, whatever it is.
Shillings and pence.
There's no Solatium award, and that's why, of course, one reason why the bereavement award was then introduced later by Parliament. And so my learned friend hasn't been able to answer my Lord Sir Patrick Elias's question. Well, does it mean, even if the tort has indirectly caused the removal of the children, that you can still claim the cost of children by definition? You won't be costs you won't be incurring.
Commercial cost.
Yes, which of course is our ground one. But even if you do it in another way, for example, the alternative was her loss of earning, lost opportunity to go back to work. Again, she now has that opportunity. It hasn't been lost, and so short of there being a radical development in the law in this respect, which would have to be a statutory amendment. It remains the case that it does reduce, these facts reduce the dependency whichever way they go. In other words, if this case had been tried in July last year, we would have been constrained to say it's irrelevant. Why? The children are no longer with Mrs. Witham. I wouldn't say that with any relish, but that would be what I would submit. My learned friend referred to Mulholland, but of course Lord Wilberforce there was talking about an estimate made on the evidence by the trial judge doing his best, which may turn out to be falsified to some extent by events. But it's notable that in the Notting Hill case, citing the paragraph, I don't know what you've read the paragraphs, but first of all citing Lord Justice Norse in Pitalis and Grant, he himself quotes Sir George Jessel, Master of the Rolls in Ex parte first, if a point was not taken before the tribunal which hears the evidence, and evidence could have been adduced, which by any possibility would prevent the point from succeeding, it cannot be taken afterwards. And in paragraph 27 of the judgment of Mr. Justice Snowden in the Court of Appeal, he noted that one extreme is an attempt to raise a new point on appeal, which, had it been taken at trial, might have changed the course of the evidence given at trial, which would require further fact and inquiry. But what I've been labouring to say is that it couldn't have really changed anything if the only point we could take would be the standard point, perhaps based on statistics, that nothing is certain in life. So we do say that this would amount to an injustice if this court is constrained to proceed on the basis of a fiction. It may have to be remitted, and that's unfortunate. But that cannot be a reason for saying that an award of several £100,000 relating to commercial childcare, or an alternative award if, for example, our ground 3 only is allowed a slightly lower award, but going right through to March 1929, has to stand when the reality is there's nothing we could have done about it at any earlier date.
Is it now settled that if you've got two people and the survivor has greater earning power than the deceased, there is no financial dependency?
It's a matter of arithmetic, because what one is, financial dependence is always looking at the net loss, that Coward and Comex calculation, so that if, and it was conceded, we'll come to it later perhaps, no financial, because if you get, usually the survivor needs to be earning about 50% more than the deceased, because the arithmetic means that your 2/3 or 75% calculation.
Okay. I mean, I think I'm probably just out of date, because my recollection was that if you went back to Harrison Empress Motors and things like that, what you did was you aggregated both incomes.
Yes.
You then took 75 or 66%, whichever it was. You then subtracted the survivor's income.
Yes.
Well, that doesn't necessarily mean that you've got no financial dependency.
No, it doesn't, but it depends on the arithmetic. It depends how much more the survivor was earning, assuming it goes into a common pot and they dip into it, as it were, together. Because you just have to, you get to the point if it's 2/3, where there may still be the 2/3 remaining.
I see.
So I think that's right, and that seems to be the reason why financial dependency wasn't put forward in this case. Ladies, unless there's any other points, that's my reply.
Thank you very much, Mr. Kent. The court will rise for 5 minutes.
rather eaten into the day. I mean,
What do you think's there? What do you think is there?
well, I think the trouble is,
Going this way, I do think it is going to remit us and therefore dump the side of
well, I
ground.
want the sheep on it, but they might want to deduct deciding other issues. But what's the point of that?
We'll just send us back, we'll fight it again at first instance trial.
But unless we win our grounds, well, then we've got in the bag the existing approach, and you say, it's, I mean, yeah, maybe perhaps they'll say, come back and find out more about your personal situation. Come back in November, and we'll decide the other grounds. That's fine. I've got an 8-week trial in October. Actually, it's going to settle, I think, so that's fine. Need something to do in November. I mean, but I mean, these other grounds. How long do you think? I mean, I would have been half a day on those grounds anyway. I would have thought so. Maybe
Not much shorter in response.
well, quite. And we're not.
I'm
We're
just
not.
saying judges right, judges right, judges
What
right.
was our time list?
We're a day for everything.
So then that's it tomorrow. Oh well. Yeah, I don't know.
Thank you. Well, now we'll take the grounds in the order that they were originally drafted. What I do want to know before we resume is where you are on timings.
Well, I have to say that we've taken much longer than I expected.
Yes.
I'm afraid, on ground 5, and this would have been a one-day hearing just on grounds 1, 2, and 3. I believe there are quite a lot of authorities to look at.
Well,
Which is unfortunate.
we've got today.
Yes, well, I will do what I can. Obviously, my own friend needs a proper opportunity to respond.
Well, Mr. Snowden has covered a lot of his factual ground already on ground 1.
Yes. Well, lady, can I turn straight away to ground 1, but just as a preliminary to all the grounds, your lordships will be familiar with the fact that the children A and B were initially put forward as dependents under the Fatal Accidents Act. When it came to the schedule of loss, it was recognised that they were not eligible under the statute. And therefore, but by then, a care report had been prepared by Lynn Hannon, which was the foundation for the judge's conclusion on commercial care costs, and he was entirely accepted in every particular. And so, although she prepared a report evaluating the services provided by Mr. Witham to those children, it was simply, as a matter of the schedule of loss, converted into the value of the care of a services dependency. It was said that was lost in relation to provided to her as Mr. Witham's wife.
Did you accept that the services were provided both for her benefit and the children's benefit?
Well, no. They were provided. They were jointly providing services for the children's benefit, and were paid to do so. And that is an important feature of the case. But there is no doubt, we submit, that if they had been eligible dependents, the case would have been a straightforward one, put as being a claim by the children as dependents who've lost the care provided by Mr. Witham. Although it was acknowledged by my learned friend, and indeed found by the judge, that as it happens, they suffered no loss. The reason they suffered no loss was it was suggested because Mrs. Witham has taken on the care, but in fact we say there's no loss because they were in the care of the local authority who discharged their duties through the agency of foster carers, and that continues to be the position. That we say is the correct way of putting it. So that even if, by way of amendment, the statute had added foster children to the list of eligible dependents, then the problem, we say, this is an unusual case. This is not a gratuitous care case of a conventional sort where the loss of the parent then has to be replaced. So not only were they not eligible, it was conceded the children would have suffered no loss. It was conceded, as we've discussed earlier, there's no loss of financial dependency based upon Mr. Witham's income. And she was a joint foster carer with her husband, as I've said, and received an allowance and various expenses. The case was put on two alternative bases. One, the commercial cost of childcare and some other items, but principally childcare. That is to say, replacing what Mr. Witham would have himself provided had he not suffered an untimely death. Alternatively, the loss of earnings suffered by Mrs. Witham through her inability to pursue a plan that we accepted she had formulated to return to work as a specialist nurse. There were some issues of fact which the judge held against us on what that would have involved. And so that was in the schedule of loss, which is in the supplementary bundle. I hope I don't need to refer to it, but the court may just need reminding. Pages 12 to 14 of the supplementary bundle set out these claims. And the judge held as a matter of law, paragraph 59 of the judgment, that the alternative way of putting the case was not available. That is to say, her loss of earnings was not something she could claim within the scheme of the Act. It's not appropriate to value the claimant's dependency on the basis of the claimant's loss of earnings and pensions loss, which I find is not within the ambit of Section 3(1) of the Fatal Accidents Act. Although, as we'll see in a moment, his identification of why there was a loss seemed repeatedly to focus on Mrs. Witham's lost opportunity to go back to work. And I'll come to what he said about that in a moment. There is no respondent's notice seeking to reopen that finding by conclusion by the judge. I have raised in my amended skeleton argument the significance of an EAT case, National Union of Professional Foster Carers and Certification Officer, which has now been decided by the Court of Appeal, and it's in tab 24 of the authorities bundle. It has some relevance. I'm not going to take time taking the court to it. It's necessarily, so far, unreported and a lengthy judgment of the Vice President of the Civil Division and also a short judgment of Lord Justice Bean. But the short point there was that foster carers, under a similar arrangement to this one, were held by this court to be in an employment relationship with the local authority who had the care of the children. It was a slightly convoluted case because of a previous decision of this court, W and Essex County Council, which held that there was no contract between foster carers, the court, and the local authority. The case had to be decided rather artificially under Articles 11 and 14 of the European Convention, because these foster carers were discriminated against not being allowed to register as a trade union because they couldn't show they had a contract. That's by the by, but the decision of this court was that a foster carer was in an employment relationship, which has some relevance to what one is looking at when one looks at the authorities in this case. The paragraphs I would invite the court to look at in that judgment are paragraphs 21 to 27, which set out the statutory framework, 47 to 53, which set out the payment regime and the favourable tax treatment of those payments to foster carers, and the conclusions of the Vice President at paragraphs 88 to 95, also the short judgment of Lord Justice Bean at the end. Here, the claimant continued to receive the fostering allowance, which we submitted. It's in the closing submissions in the supplementary bundle of pages 78 to 79, gave her not far off £60,000 per annum net, which included some benefits that she was entitled to claim on behalf of the children. And indeed, we pointed out that in her CV, she described herself as her work history as including fostering children. That's background, but it illustrates a point I'm going to come to, which is that in effect, despite the undoubted fact, which I need to emphasise, I'm not seeking to resolve from, that this was a loving family who fostered children for reasons the judge said for their own benefit and as well as for benefiting the children. Nevertheless, it is a paid employment for the local authority to provide the care that the children need. In other words, it's for the benefit of the children, primarily, whatever the motives of those who...
So it's the logic of your case that whenever it's paid employment in this sense, if it's done, as it were, partly as work, as also for family reasons, putting it very broadly, that you always ignore the family reasons, that they can't, as it were, trump the fact that this is really a business relationship.
Yes, it is, my lord, and I think it's probably a good moment to come to Burgess and Florence Nightingale, which is an important case, although it's first instance, Mr. Justice Devlin. It's been acknowledged and approved a number of times by this court. because, and I think that it's worth doing that straight away. This is at tab 5, thank you, of the authorities bylaw. It was the professional dancing partner case where the wife was killed and the husband and the dancing the business necessarily came to an end. They could no longer perform as a couple. And Mr. Justice Devlin, one turns to page 356, engaged in quite a detailed analysis of the case law. He first refers to a personal injury case, Best and Samuel Fox, which established that there's no claim by those who are indirectly affected by a tort injuring someone with whom they have a relationship. The servant whose master is killed or permanently injured may lose his employment, and so on. And he then comes, the last paragraph, having quoted Lord Goddard in that case, says, look, Mr. Justice Devlin says, that being the general principle of common law, it is in the light of that one must interpret the words of the Fatal Accidents Act, which are extremely short and wide. And then he quotes what was then Section 2. It's the same wording, I think, as Section 3 of the current Act. And goes on over the page to say, if one were merely to apply those wide words to this case, I think this case, I think, would fall within them, because it is an injury which resulted from death. But those wide words have been restricted by a series of decisions which really make a complete exegesis. And he then looks at, he gives some examples of other cases where someone might indirectly suffer loss as a result of the death of someone else, the young partner whose senior partner is killed, or the, and he says in the middle of the page, can it make any difference that the senior partner is a father who has taken a son into the family business? In other words, someone who is eligible to claim under the Act as a son. The relationship in such a case as that is purely incidental, and Mr. Marshall submits that's also the position in the present case. And then
wouldn't we rationalise this in slightly more modern language by saying it's pure economic loss, and there's no duty not to cause pure economic loss, and that doesn't apply to Fatal Accidents Act?
Well, well, my lord, that would be true in the personal injury claim, the tort claim. But Mr. Justice Devlin is starting with Best and Samuel Fox and saying it's the same principle that applies to a claim by a dependent. I entirely accept that pure economic loss is not an answer to a fatal accidents claim. In fact, most of them are pure economic loss cases, financial dependency loss. But Mr. Justice Devlin is then looking at the case law, and we'll come to it, which shows that the same rule applies. In other words, if a junior partner who happens to be the son of the owner, whose father is injured and is unable to continue with the business, suffers loss, he has no claim. If his father is injured so badly that he dies, equally he has no claim under the Fatal Accidents Act. It seems to be what this case is saying. And at the end of that page, starting the words, I think it is clear that the authorities established, your Lordship see that, but if the benefit arises out of the relationship, it need not be a monetary benefit. It can be services rendered, which can then be translated into money. If a relation out of filial duty or any other motive that arises from relationship renders services to the plaintiff which he gives either free or at less than the market rate, the loss of those services is something which can be translated into cash and is recoverable under the Act. And I emphasize the words either free or at less than the market rate. He then refers to Franklin, South Eastern Railway Company. The father earned 3 and 6 a week, carrying up coals, but he was not able to do that himself, so his son carried them up for him so that he could earn the 3 and 6 a week. The son was killed, and the father was able to recover the value of those services. And he ends that paragraph, the son was by reason of the relationship rendering services free to his father. And then he refers to another case, Condon and Great Southern and Western Railway, where the judge gave a direction to the jury, I think, it's an Irish case, and what is said just below the middle of the page, that direction I take to mean that if the son had continued to live and so on, he would have, in fact, have worked for his mother in a way which would have enabled his mother to earn more, meaning thereby that he would have worked at less than the usual wages. By working at less than the usual wages, he would have given his mother the benefit of his labour. And he refers back to the Franklin case. And then in contrast, there is Sykes and North Eastern Railway, where the son assisted his father and the son was killed. According to the father's evidence, he employed his son and he paid his son 33 shillings a week as wages. And his son used to assist him. And then after the next paragraph, that claim was disallowed, and Mr. Justice Brett said, the plaintiff gave no evidence of a pecuniary benefit accruing to him from a relationship. The son worked for his father, who appears to have paid him a full amount of wages. Mr. Justice Grove said he was deriving an advantage from a contract with his son, and Franklin is clearly distinguishable. In that case, the son worked for nothing, and here the father paid wages. And what that leads to is a conclusion of Mr. Justice Devlin at the last paragraph on the next page. I think that all those authorities are consistent with the principle which is stated in Sykes' case. Even without the assistance of those authorities, I should have arrived at the same conclusion of principle, and that is that the benefit to qualify under the Act must be a benefit which arises from the relationship between the parties, and therefore that is the question which I have to determine in this case. It is important to note that here the wife's services were fully paid for. That is to say, she took her full half share of the joint earnings. Not suggested that the arrangement was particularly beneficial to the man, and so on. Then the question is, did the fact that they were earning that joint income arise from their relationship? It was not unconnected with their relationship. I think the relationship was a very convenient and usual incident of the partnership. It is convenient, of course, if a man and woman are constantly going about together and staying at hotels, and it greatly eases the position if they stay as man and wife. It adds that element of permanence to what otherwise might be a pure business partnership, but those, in my judgment, are only incidental matters. Then he says, I think it's stressed by the fact that the husband and wife relationship was superimposed upon the partnership. They've been together as professional partners, sharing their income for years before they were married, and there are in existence in the dancing world dancing partners who are not married. And although no doubt the usual thing is to find them married, that is not essential.
But they didn't take up dancing because they were married.
No, they didn't. But what Mr. Justice Devlin is saying is that it remains incidental, even though it may be a family decision. To translate to this case, foster carers don't have to be married. The judge says, well, it was a family decision. We understand that, and we can't challenge that finding. But it remains incidental.
I'm sorry, whether or not it remains incidental is itself a finding of fact, isn't it? I mean, in this, if the judge had said, I find that in essence, they're in the business of foster care.
Yes.
And I can see a complete analogy with what you're submitting. But isn't the judge's finding of fact that they're not in the business of foster care in that sense? That it's a very different relationship they have with these children than normal foster parents.
Well, my lord, what we say is that it cannot be the case that it makes a difference. If as an objective matter, this is an employment activity, lots of people enjoy their jobs, and they do so. Often married couples work together and run a business together. But if the court has to get into an inquiry as to the motives, whether mercenary or the opposite or something in between, it would be never-ending. And the point that Mr. Justice Devlin was saying was that it may be very convenient in their case to be married. It's a glimpse of another world, perhaps, the dancing partner, married dancing partners. But it nevertheless is incidental. And we say he's saying that because the income, which is fully paid for, the work of the services provided by the deceased was fully paid for. And that was her occupation. And applying the rule in the personal injury cases, he has no claim for his loss of income, which is, as it were, an indirect consequence of her death.
But isn't there a consequence here for family reasons that she feels obliged and felt obliged to carry on looking after the children alone?
Yes,
It may not happen in a straightforward business relation.
no, that is true. And my lord, we accepted, this is an important point my learned friend will later emphasise, that her plan had been to return to work, and that in the near term she was prevented from doing so. We did take issue as to whether that would in fact be the case throughout the period of fostering, because as the children grew older they'd go to school. But under the current arrangement, the foster carer had to give up any alternative employment. So as a matter of fact, we accepted that.
But not just, I mean, sorry to interrupt,
Yeah.
but I mean, it's important, isn't it, that it's not just what the local authority required, it's what they felt was appropriate. Because the local authority requiring it, you might say, well, that's still a business, in essence, a business matter. But here, as I understand it, it was rather different.
Well, my lord, I'm not sure when your lordship says what they thought was appropriate. Does your lordship mean the local authority or
No,
with them?
The parents themselves.
The couple, yes. Well, it brings one back to this point that just as the son in the Franklin case was happy to help his father carry the coals upstairs because he was his father and was not even not getting paid for it. In the other case, the Sykes case, the payment was, the services were fully paid for. And that, I think, is the point that I'm seeking to make here, because we're dealing here with the services, with a services claim said to be provided by Mr. Witham to his wife, not dealing with this alternative case of a loss of earnings claim, but by Mrs. Witham. And so that case is then taken on by some other cases, but I think Malin and Plummer probably comes next in the it comes next. It's tab 7, 1961, and that was a case of a widow whose husband was running a one-man business. It's important to emphasise that. We see that from the beginning of the head note. It was a one-man business, but he had incorporated his business in the form of a private limited company, and his wife was, and he owned all the shares but one. His wife was employed in the business for limited duties, but it was acknowledged she was paid above market rate. And this court said that the above market rate element could form part of the financial dependency loss because, in effect, it was a way of distributing the profits of the business in a tax-efficient way. And they weren't put off by what was called the interposition of the limited company. But it's important to note that her earnings, her own earnings, as it were the market rate earnings, were disallowed. And so if one turns to Lord Justice Sellers at page 343, just below the middle of the page, he says, she was a director and secretary of the company with at least nominal duties. I would assess this on such meagre evidence as is available at £200 with no likelihood of increase in services to be rendered, and reduce the dependency on the husband, therefore, to £1,175.
Sorry, where are you?
I'm sorry, it's about 2/3 down the page. I would assess this
yes,
slightly above that. And so Lord Justice Sellers reduced it, and indeed so did the other members of this court. The page 346, Lord Justice Pearson says at the last main paragraph on that page, in my view, the figure of dependency, £1,375 per annum, should be reduced not by the excessive amount of salary, which was nominally allocated to her, but by so much of it as she really earned, that is the amount of a reasonable remuneration. So the £200, which as it were related to her real earnings, were disallowed, even though the business had come to an end when her husband died. And Lord Justice Diplock cites at page I think this is quoted in our skeleton, page 349, cites Mr. Justice Devlin in Burgess and other cases. Top of page 349, long been established, despite those wide words. First, the pecuniary losses to the persons for whose benefit the action is brought is the only damage recoverable. Secondly, the pecuniary losses are limited to a loss of a benefit in money or money's worth, which, if the deceased had survived, would have accrued to the person within the defined relationship and would have arisen from that relationship and not otherwise. And the third case in this line is Cox and Hockenhull.
Do you want to deal with that now or after the short adjournment?
Well, could I deal with that? Because it's very short reference.
All right.
Tab 15, and this was, again, an unusual case. The wife died, the husband had been in receipt of invalid care allowance because he was looking after her, and he claimed that as part of his lost dependency, and that was refused by this court, and it was explained, Lord Justice Stuart-Smith Senior, I should say, paragraph 16 set out the rule under the Social Security Contributions and Benefits Act, and made the point at the end of that top of page, the next page, that it's an allowance that may be paid to anyone who is severely disabled. It is no way dependent on the relationship of husband and wife or any other to which Section 1 and 2 of the Fatal Accidents Act applies. And just pausing there, of course, it presumably was the case that Mr. Cox was looking after his wife because he was her husband. In other words, just as in this case, on the facts, no doubt, he was her carer because he was married to her. He wasn't a complete stranger. But as it happened, the legislation didn't require him to be married. And then in paragraph 18, in my judgment, having quoted from Best and Samuel Fox again, so the one House of Lords decision on personal injury claims, paragraph 18, in my judgment, that is the position here. In effect, the state employed Mr. Cox to care for a severely disabled person. If that person had been anyone other than his wife, the fact that she died and Mrs. Cox thereby lost his income would not give rise to a compensatable loss. The fact that the relationship of marriage existed is, as Mr. Justice Devlin put it, incidental. And so we say that is yet further support for our submission in this case, that one doesn't get into that invidious inquiry of what are the motives and so on. This was a paid occupation, which did not technically require the relationship of marriage. And this is, therefore, a claim which falls on the Burgess principle. That probably is a convenient moment.
Right, thank you very much indeed. 2 o'clock.